We are back with Nicole Patino of Law Offices of Nicole Patino and Gabe Snyder of Ward Black Law, discussing workplace issues and workers' compensation as well. All right, so this question is, I was terminated because I've been out of work on FMLA due to a heart attack. Is this legal?
So that depends. Now, if you were dismissed purely because you were out on FMLA, that could be an FMLA retaliation claim. If your employment was terminated because you completed or finished the full 12 weeks you're entitled to under FMLA, possibly. But if you requested that the employer allow you more time, or you are able to return after some period, and that period would depend, the employer should have engaged in the interactive process with you under the Americans with Disabilities Act. So there are a couple of laws that might be at play there. So maybe, but I would definitely talk to somebody about the circumstances regarding your separation from employment.
And when you say talk to somebody, you mean talk to a lawyer and kind of give them all the details of the things, and then that way they will be able to kind of guide you into what can or can't be done.
Absolutely. You can talk to an attorney. You can call the United States Department of Labor, who enforces FMLA violations, or even the EEOC, who enforces the Americans with Disabilities Act. And they may be able to guide you as well.
Okay, so they have options there. All right, so Gabe, if someone has been receiving workers' compensation for years now, and the employer is saying that the benefits are no longer owed because they reached this max of 500 weeks, what is this all about?
Yeah, So back in 2011, there was an amendment to the Workers' Compensation Act. What it used to be is that if you had not a catastrophic where you die, but a significant injury that kept you out of work, then workers' compensation, just as long as you prove that you were disabled under the same standard, that you would be entitled to benefits for your entire life. So back in 2011, the legislature changed that to add a new term, which lawyers love to fight over. That's what we do. But they called it total wage loss capacity, which we've never seen before. And so it set this new standard. What does that mean? What does that look like? Does that mean that I'm literally cannot do any work at all? I'm not to be disrespectful, but like a vegetable, I can't do anything? Or does it mean that I'm capable of some work? And so that process being 500 weeks, the amendment happened in 2011, and 500 weeks coming up right around now, lawyers are starting to litigate that issue. And so if you have a claim where your employer is telling you, hey, we're done 500 weeks, you absolutely need to call a lawyer, because it's really gray what the answer is.
Yeah, and you don't want to be leaving any kind of money on the table.
No, and don't just let them tell you that that you don't get any more, because that's not true, right?
Okay.
It could be that you're entitled to more, to further weekly payments through TTD, or temporary total, which is like your weekly wage loss.
Gotcha. Okay. All right, Nicole, this person is asking, I work as a server and do not get a break during a 7-hour shift. Is this allowed?
So unless you're a minor, it likely is allowed. Now, again, if there is a medical reason that you need a break during that time, you may be able to request a reasonable accommodation under the Americans with Disabilities Act. But otherwise, breaks are not required.
It's not like every employer has to give you a 15-minute break every 4 hours that you work.
Only if you are a youth worker. So under 18, under 16.
I didn't know that.
Interesting. Okay, we're all learning a little something here. This is good. All right, one more employer kind of related question. I was laid off with no notice. Shouldn't I have been offered a severance package?
So in North Carolina, a severance is a gratuity. No employer is required to offer one unless there's an employment agreement that you have that says it's required, or there's a severance pay plan.
Okay.
So no, maybe not.
Maybe not. All right. Gabe, this person says, is it legal for a company, hold on. Let me get to this one. Is an employer obligated to let you to return to work after being out on long-term disability if you were out on workers' comp?
Okay, so I'm assuming that this person, you're out on workers' compensation and now you're able to return to work. So here, let me say it this way. The setting would be your employer, if you had a workplace accident, you have an accepted claim, meaning they've not denied it and there's not a reason for them to be denying you weekly payments or medical compensation. They have to return you to what's called suitable employment. And where you look first is back to the employer. But if you cannot physically do the job that you did before, the employer is required to try and get you back somewhere where a different job, maybe with sedentary if possible. But most of the time, by the time that happens to go back, they have decided and moved on from that employee, because most of the time, if you're out for a long time, they're saying, we can't accommodate, we can't hold this job open for you anymore. At that point, they're responsible for getting you vocational rehabilitation to try and find another job within 50 miles of where you live.
Okay, and so Nicole, do you have something on this? If it wasn't workers' comp, they're just on long-term disability, do they have to, are they obligated to let you return to work? Do they have to make accommodations for you?
So it depends on how long you're out of work, but typically if you're on long-term disability, what that means is that the employer or their insurance carrier has determined that you are disabled, so you're unable to work. If you're able to return to work, so let's say that kicked in after 3 months, 6 months, you can return to work. If the employer has a position, they should return you to work. They can, they don't have to, but if you're able to go back to work and you do need accommodations, then they are required to engage in that interactive process with you under the Americans with Disabilities Act.
All right, you need to talk to HR about that if you're having issues with that.